Morning.
Morning. All ready for me?
Ready to go.
All right, morning. I'm Jason Herman with Herman of Wells here on behalf of Brick McMahon Industries. May it please the court, I'd like to reserve 3 minutes for rebuttal, if I could. The complaint in this case sets forth a number of different wrongs committed by Regatta against Brick McMahon. Those are separated into 9 different counts, each of which lays out the elements of the causes of action of each of those respective counts. This is a case that should not have been dismissed, and it definitely should not have been dismissed with prejudice. And some of these are very straightforward when you look at them.
Can you explain your argument as to count 6 unjust enrichment claim, the dismissal as to the concept that your client forego for the monetary claims for non-monetary sorts of things, and I just don't understand the unjust enrichment part of at least that argument in the count 6.
Sure, I think
because the argument is that Regatta received the full benefit of the bargain. Explain that, please.
well, the bargain said that the case, the 2007 case, would be dismissed and that case was wrapped up, which it is. In exchange for that, there was money paid, but there were also a series of non-monetary terms that were promised and not delivered. And a number of those were not delivered because Regatta didn't authorize its board in the way it should have prior to entering into that agreement. And so we've got all these terms which, unless Regatta was in there committing fraud, had value to both parties because it was a trade. It was an arm's length transaction where Regatta was getting something, and this was their payment. It had a value, and they didn't have to pay it because it was found that Regatta did not properly provide authority to its board, which is that's the third element of the unjust enrichment cause of action, which is it would be inequitable for Regatta to retain the full value of what it got when it didn't give the full value of what was promised.
Thank you, counsel.
And that's probably the most complicated of all of these. The least complicated is the breach of contract, because we have here an enforceability hearing that took place, and there were terms that were found unenforceable, but there were some terms that were found enforceable, and there were some that weren't challenged and according to the briefs are in full force and effect. One of those terms was the return of these 2 storage units through a 99-year lease, which was an obligation that Regatta had in the settlement agreement. Judge Baird found that was to be enforced, and it just didn't happen. And just so you know, these storage units were the pantry of the restaurant. They were about 30% of the square footage of this restaurant space. It's not an insignificant issue here. They had actual value, and it just didn't happen. And in the answer brief, there's no justification given for that. This is a breach on its face, and breach is really easy to plead. Contract, that's the settlement agreement. Breach, obligations, like return the storage unit. Damages, you didn't get the storage units when you're supposed to.
Can we go over so I understand as far as the enforceability? There were certain provisions that were enforceable. One was, as you had stated, the storage units. I want to be sure that it was also the parking areas, the poolside dining and room service. Am I correct on that one as subsection C3?
Yes, Your Honor.
And then the access to the restaurant and the salon spa, and then, kind of putting that sign back up.
Right.
Those were found to be enforceable, but this was dismissed as not breaching the contract.
Right. The allegation was these were
Right.
not delivered, and I don't know how the judge got there. There's also the last one.
Well, I don't know how it's defensible here to defend this, but I'll ask that question to your friend. Continue with your argument, please.
And just the last one was the cooperation with getting approvals, and that might seem like it's not an issue, but the city of Clearwater actually won't let like a sign go up without the board approving it. So it was actually a really important issue there, and it kind of tied in not just to the construction issues, but even to the enforceable issues there. So that's one other that was alleged to be breached as well. Another straightforward one is this failure to maintain common elements. The declaration says that water lines are the responsibility of the condo association, and the allegation is they didn't maintain them. It flooded the unit. That's the breach. It caused damage. A flood. It actually caused physical damage. And more than that, there was a tenant in that space.
And all of these were alleged?
All these were alleged, yes. And the argument, there's not an argument that they weren't alleged. The argument in the answer brief is about timing, that this damage happened after the settlement, before the dismissal of the 2007 lawsuit. But we know the settlement doesn't matter because the agreement says it only applies to claims that run up through the date of the agreement, which is December 1st, 2010. This damage happens on December 17th, 2010. So it just can't apply. That's 2 weeks later. Then if we look at the dismissal, that dismissal is of the 2007 lawsuit. I'm not really sure why that matters. My guess was it was a res judicata argument being raised, but res judicata can't apply to a cause of action that didn't exist when you filed the lawsuit. Also, we don't have an identity of the issues or the cause of action. And it's also, that's something you have to raise in affirmative defense. It's not grounds for dismissal. So that argument doesn't work for anything here. This needs to be reversed. We also have, really we can deal with the trespass and the 3 tortious interference claims as one issue, because the issue there is control. Did Regatta have control over Brick McMahon, how it ran its business, what it did with its units, what people could come in there? And that whole argument from Regatta hangs on this provision in the declaration that says these units should not be used for hazardous, unsafe, nuisance purposes as determined by the discretion of the reasonable discretion of the board. But there's no allegation in the complaint that any of these things are hazardous or unsafe or a nuisance. I mean, these are leases that are with restaurants. People who want to run restaurants, and restaurants are specifically allowed by the declaration. And you know, even if there was some argument that you could draw an inference here, that's not something that can happen on a motion to dismiss, because inferences have to be drawn in favor of the non-movement, which here was Brick McMahon. And then if you look further in the declaration, you actually see that the control that was exercised by, that could be exercised by the association was very limited for these commercial units. The association didn't have a right to object to their use or their leases. It could not restrict or limit the leases. Approval was not required. They could be leased and used without the association's consent. And the owner of the unit was allowed to use it, allowed to let the public in, which is the argument for why they were allowed to kick people out, was because they were the public, but that's allowed by the declaration itself. So there's not an element of control here. I mean, the fact that Regatta thought it had the control is what led to this case, because they felt like they could kick people out, but that's not what the declaration says.
On count 4, it's the fraudulent misrepresentation claim. Can you tick off the prima facie case there and the factual support there? It seems like it's melding and trying to stand on its own as compared to count 3. And I'm trying to find the facts that stand to where the fraudulent misrepresentation was there, which it almost sounds just like the breach of the express warranty. The real difference between those two, I mean, they're virtually identical. They involve the same issue, which is that warranty of express authority. The difference is that for fraudulent misrepresentation, there's got to be a knowing intent to deceive. And point me to the part of the Fourth Amendment complaint that supports that. You cite to page 16.
Your Honor, there's a
I'm sorry, it's page 2517 of the record, page 16 of the Fourth Amendment complaint. So in footnote 10, is the allegation that Regatta Association acted fraudulently and is representing or claiming to be broke, when in fact it was days away from settling the multi-million-dollar lawsuit with the builder?
No, Your Honor,
I'm just looking for that factual support to meet that element which distinguishes it.
I'm looking for the paragraph. I believe the allegation was that in a prior meeting, the board understood that it didn't have the authority. Give me a moment, I'll find that.
I see paragraph 95 is close to that. Paragraph 93 is close to that. I'm just trying to find the difference between the two counts.
Well, and part of it is in 97 where it says that the board knowingly made a false statement. I mean, that's a conclusive statement, but that's an allegation that they knew.
I understand.
Yeah, and then actually, it's the footnote on page 16 of the complaint, which is on the record, it's 2517, that it says this allegation is supported by a written statement from a former board member. In that statement, that board member acknowledged that he and Tacobo, who's the board president, had informed the board and its attorney that the board did not have authority to encumber common elements, and that this information was provided to the 2010 board and ignored.
So this is just alleged, right, and it's just part of the complaint?
Correct. That's a footnote.
So within the four corners of this, it should have survived at least the dismissal, is your argument?
Right, and it's basically that's the evidence. That's the allegation that there was a knowing fraud here. It wasn't just that they entered into this thing and they promised something and didn't deliver it. Whoops, we didn't know. That's breach of warranty. You don't have to raise that level. But for fraudulent misrep, we do. And that's the allegation there. It's said on its face it was knowing, but that footnote 9, explains how we know it. There was a discussion ahead of time, and they still went ahead and entered into this agreement, and then a month later are saying, sorry, we don't have to give you anything that we promised. And so, and of course, the elements there for both those counts, both the breach of warranty and for the fraudulent misrepresentation, they're pled, and so it should have survived dismissal as well. And the argument raised in the answer brief is that these were statements made in negotiations. And as to we're broke, fine, I get that one. But as to the real core issue, which is that warranty in the settlement agreement, that was not part of negotiations. That was the culmination of negotiations. It's in the settlement agreement. So there's cases that talk about negotiations. If you fool me once, fool me twice. I mean, this is written into the agreement, so you can't be fooled twice. Because if the warranty is complied with and the board is properly authorized, all of these terms are enforceable. And the only reason they weren't is because the board was not authorized, which is just flat on its face the opposite of that warranty. And so those counts also need to go forward, and the trial court needs to be reversed on all counts. Unless there are any other questions, I'll sit down.
I'll save you 3 minutes.
Good morning, may it please the court. Todd Boyd on behalf of Regatta Beach Club. The case began back in 2007, as the court is aware, with the lawsuit filed by Mr. McMahon that was settled in 2010. Subsequent to 2010, there's been a series of complaints filed. A series of issues have been raised with the trial court. There also was a diversion to bankruptcy court for a period of time as well, where other claims were asserted there. The brunt of appellant's claim post-settlement, as it relates to the settlement agreement, has been an attempt to work around the terms of the settlement agreement, keep the $250,000 that it was paid, $200,000 in cash plus $50,000 in credit, keep the other benefits of the settlement agreement, but then avoid the severability provision of that agreement, and now seek particular damages for those provisions that were stricken by the court as unenforceable.
Is that similar to what Judge Baird did previously? There's an order from Judge Baird, I think 2008, was it?
There's two actually from Judge Baird in 2000, I think 2012,
okay,
where he addressed certain of these non-monetary provisions, found some to be enforceable, some to be unenforceable, based on the fact that the unenforceable ones would require ultimately approval of 75% of the owners because it impacted common area of the association. But what appellant seeks is to ignore the severability provision. This agreement, for various reasons, and none of us here were parties to the negotiation of the agreement, but the severability provision is extremely broad, and it provides that if any one or more of the provisions of the agreement should be ruled wholly or partially invalid or unenforceable by a court of law, then the validity and enforceability of all provisions of this agreement not ruled to be invalid or unenforceable will be unaffected. The risk of some of these provisions or portions of the agreement being found to be unenforceable or violation of Florida's Condominium Statute Act, which compels there be a certain percentage vote to affect common areas, was a risk assumed by the parties. What appellant is asking as it relates to the stricken items and some of the remaining items is to change the language of that severability provision. Normally, a severability provision contains at least the term materially. If any immaterial provisions of the agreement are stricken, then the remaining portions of the agreement remain effective and legally enforceable. Here, that's excluded. What appellant essentially ultimately argues is change that provision so that we exclude the tiki hut, the awning, the open passageway, the hallway modifications, boat room use, garage use, with the items which are the items that were stricken.
What about storage units?
Yes, sir.
Those are excluded. Tell me the effect of giving back these storage units here and how they, given that it's an enforceable provision, how failing to give them back on the face of the complaint is not a breach of contract.
I think the issue the judge took with the fourth amended complaint was the fact that the appellant did not parse out those items that were not stricken from those that were. The appellant continued to sue.
So why is it with prejudice here?
I think the judge's issue at that point may have been because it was the fourth amended complaint.
The judge was frustrated.
I don't know if he was frustrated or what drove him in that regard, but in all of the, I break it into two separate issues. We have the pre-settlement, settlement type issues, which is this express warranty and fraudulent inducement. Those claims the judge struck with prejudice for different reasons. There are the post-settlement claims, which are the breach of the provisions breach of the non-monetary provisions not stricken, as well as the tortious interference claims. Same thing as to the tortious interference claims. The appellant brought in allegations related to the items that the court had stricken. The plaintiff or appellant alleged in the tortious interference claims that the tortious interference as a result of the claims having been stricken was a result of the fact that the non-monetary items were material to the leases that he was either negotiating or claims to have entered into with others that form the basis of those claims. And the interference as well there is not something that would constitute interference. But again, he kept tying everything into one piece as opposed to parsing it out. So as to some of the post-settlement claims, I think that may have been the judge's rationale. As to the pre-settlement claims, the provision that the appellant relies upon under the express warranty claim, as well as the fraudulent inducement claim, is the warranty concerning authorization. Now, as alleged in the complaint, and counsel was not a party to the proceedings below, but I think it was incorporated into this brief, the actual provision is not what has been argued or what was quoted in the complaint. What was quoted in the complaint was that the representatives who signed the settlement agreement had expressed authority to agree to the terms of the settlement and bind Regatta to them. It's not what it says. The agreement simply provides that the individuals executing this agreement have the express authority to do so.
We're arguing, and I appreciate these arguments in the background because this seems to be contested litigation over many, many years, and you weren't counsel this whole period. But I'm looking at the four corners of this fourth amended complaint here. Is the judge dismiss it for a sanction?
No, I think
So why does it matter anything outside of these four corners? Like in the motion to dismiss itself, it recognizes that the provisions are, let's see, are non-issues and remain in full force and effect per the severability clause of the settlement. In other words, paragraphs 2C2, 2C3, 2C5, which are pertaining to the use of parking, poolside dining, concerning access to the restaurant. Those are fine according to your motion to dismiss, yet it was not okay. You're defending the trial court's decision to dismiss as to those when the motion to dismiss says that those are fine. I don't understand this argument.
The court dismissed, again, I think because...
Whole cloth. It had it.
But
I think.
But my primary argument here is there are certainly provisions
So
concerning...
what would you remand on? So are you agreeing with me that the court should not have dismissed the Fourth Amendment complaint whole cloth? And if so, which are the claims that it should be reversed?
I think because it was a Fourth Amended complaint, the court certainly had its discretion.
Did it say it was a sanction?
It did not.
Okay, so tell me what you would remand for.
I clearly would remand as to, not remand, but I would clearly affirm initially
On everything,
as
whole
to-
cloth.
as to the express warranty claim, because under the express warranty claim, it is inconsistent with the terms of the agreement. It ignores the severability provision of the agreement and changes its language. And that's what appellant is seeking the court to do. For that reason, that claim, the contract claim as it relates to breach of anything that was stricken, should be affirmed as well, the dismissal. Because appellant continues to sue to recover for everything, not just what was not stricken or the non-monetary items that were not stricken by the court. Likewise, the fraudulent inducement claim, for the reasons argued in the brief, should likewise be affirmed. I understand Your Honor's concern about some of the post-settlement claims unrelated to the execution of the settlement agreement itself.
But this just sounds, I mean, I appreciate you articulating these arguments well. What I am concerned is that this sounds an awful lot like summary judgment type arguments here, not based on what's on the face of an amended complaint. Explain to me how I'm wrong.
I think because the court...
I mean, you're talking about things outside the four corners here.
But I'm also parsing different sections of the complaint or different claims from some of the claims I think you're addressing. Because again, I still believe that as to the settlement, the inducement, the breach of warranty claims, I think the court's decision is absolutely solid as to those. As to some of the post-settlement claims, the issues you're raising, I understand. I think, again, the court, because it was a Fourth Amendment complaint, was exercising some discretion. And I think because the plaintiff alleged...
But the order doesn't say what you're saying.
It does not, Your Honor,
Okay,
no.
because it says the court concludes in its discretion that it is apparent that the plaintiff cannot amend the complaint to state a cause of action.
And I think that...
And is that the legal standard? Does the court have discretion to
given
say
the-
you can't amend that?
It's
Or is
so-
it a de novo? As a matter of law, you can't amend under any scenario to state a cause of action.
I think at some point the trial court has to make a
The Fourth
decision.
Amendment complaint really is a red herring.
I-
I'm just, asking if you have a different take on it.
I think the Fourth Amendment complaint certainly was an issue for the court, may have been, but I don't know. Again, the
But
judge
it
did...
went off on a tangent. It cites the case law that you can't dismiss a complaint without giving the party an opportunity to amend, unless it is apparent that you can't amend. So
And I
it's
think-
relating back to that standard.
I think the issues that arose as to the inability to amend here is the fact that the plaintiff, or the appellant in the tortious interference counts, alleged that the non-monetary items were material and part of the leases that he had sought to obtain or that he had obtained. In the fact that he obtained leases with those non-monetary items that were stricken as part of those leases, which he has alleged, I think was one of the issues the judge took with this, meaning if the tortious interference claims are premised upon things that were already stricken as non-enforceable, how can he sue now to recover for tortious interference as to those items? I think it was his inability to parse that out and to say again that...
Wasn't that the burden on the judge to go into each of those complaints and the judge threw everything out without separating out count one through however many there were?
The court certainly could have done that based on the arguments that
It
were...
will be easier for us to digest what the judge did and why.
Certainly would be easier for all of us in that regard.
I'm guessing the judge prepared this order himself?
Certainly would have been easier had the judge sorted it out and addressed the issues count by count. The arguments made below at the hearing on the motion to dismiss, though, were somewhat different. In those arguments, counsel contended that there were other verbal, oral statements made prior to execution of the settlement agreement. That got wrapped up into this as well. Counsel now, I believe, has narrowed those claims down to simply the violation, as they see it, of the express warranty provision, which again, I believe is excluded by the severability provision of the agreement, which is why if the court is reversing, that those particular claims, so that we can move from how we got to a settlement to what happened post-settlement, could then be addressed below if that's what the court is leaning. But I would hate to see the court reverse in its entirety, so we now go back and relitigate all of the items that led to the settlement agreement, how it was entered into, and why, given the fact that the parties did strike a bargain. They included the severability provision, which applies, which has eliminated certain of these items, but that provision is now the premise of the express warranty claim and the fraud claim that's been asserted.
So there still is no concession by your client as to the breach of contract claim, as to the items I previously said. I'm waiting to hear that. There's no concession as to the storage units, etc.
As it's pled, no.
Okay. I understand your argument. I understand it.
But again, my distinction really has to do with those other claims, in the fact that...
But you're still defending it that they're not pleaded a prima facie case for breach of contract?
Given the period of time that has passed and the fact that it's a fourth amended complaint, I think...
What is period of time that has passed?
Simply because at some point...
Is that an element of breach of contract?
Simply believe at some point a court should have the ability to dismiss a complaint. Here, I understand...
Had the court articulated it, perhaps, as well as you're articulating it now, I think that this may be a different case, but the court went forth and said, there is no set of facts that you could possibly bring me to set forth in any of these 9 counts anything with prejudice. That's I think, what the court may have been, that's what we have to review here, counsel.
No, and thank you for that. I think the court, there was a long period of time that passed from the hearing until the date that the ruling was entered. For whatever reason, why the court didn't fully address its rationale for its decision, again, I'm speculating. I just simply don't know.
Yes.
But also, just back to the express warranty and the fraud and the inducement claim, again, the language that those are based upon as it relates to the representation of authority is simply that the individuals executing this agreement have the express authority to do so. They did. The president of the association was authorized by the board to sign it. Appellant is not contending that he lacked authority to sign the agreement. Otherwise, appellant would have to return the $250,000 that it received. The releases that were exchanged as part of the agreement would be invalid, and there would be nothing left to enforce or sue for breach over. It would be that the agreement in and of itself is unenforceable. So the fact is, based upon the agreement and, again, the severability provision, those counts do not state causes of action that are viable. They could not be amended to do so. And as to those claims, would ask that the court reverse the, or affirm the court below.
All right.
Thank you.
Thank you, counsel.
You asked for 3 minutes rebuttal, and I've got it saved for you.
Let me just first address the fourth amended complaint. This record is really big because procedurally this was tacked on to the prior case.
Well, who prepared the order on appeal?
The order? I think the judge did. That's my
So
understanding.
there's a 5-month delay in the hearing and when the order comes out, approximately.
That's
And
what-
no one's claiming, though, because I didn't see it in the briefing, that there's something in that delay in and of itself that causes pause for concern. There's an inconsistency, improper fact alleged or recalled, because the judge doesn't go into detail except this pretty generic statement about the court in its discretion, and he's thinking, well, it's Fourth Amendment, but the discretion part is throwing me for a loop. I just don't see that as a legal standard on a motion to dismiss.
I felt the same way, and, you know, I had to go back and make a timeline. That third amended complaint is actually in 2009. It's April 30th, 2009, and so that's before the dismissal of the first lawsuit, because it's in that first lawsuit. And the record site for that is 1207, is when you're going to see that third amended. So yeah, this is called fourth amended because procedurally that's where it comes in the case, but it's 9 new counts. So I think it's really more accurately called a first complaint that was dismissed. And maybe the trial court hadn't had an opportunity to go through the record, and this is a new judge who's taken over and didn't realize that the Fourth Amendment is actually the first complaint, and that's where it comes from. But we have the record here, and this is truly a first complaint. And so if there's an inclination that there should be some kind of parsing out of anything, if that's the issue, that's classic amendment stuff. I mean, that's dismissal without prejudice, and come back, fix your complaint, take out the stuff that's offensive, and bring it back. And that's at the minimum what needs to happen here.
Well, what's the offensive stuff that you would amend?
Well, I think that there are unenforceable terms in the breach of contract that need to be stricken. That in that clause, there's unenforceable terms. And I think we say that in our brief, that we can see those issues. And so and I think if it's remanded, it can be remanded with instructions to strike those. It doesn't need to be dismissed, but those particular elements which Judge Baird found to be unenforceable should come out.
You're down to about a half a minute, sorry.
And the last issue is the severability clause can't stand alone. You've got to look at the warranty. The warranty also says what it says. It's authority. Almost exactly the same words are used to describe why these terms were not enforceable, because the board lacked express authority, which is what they promised. There should be a remedy for that. And that's all we're asking, that the case go back to the trial court and that remedy be explored by the trial court.
All right, gentlemen, you used all your time.